Hello all. In this asynchronous topic presentation, I'm going to introduce the attorney's duty of confidentiality to the client. I'll also talk about the way that it relates to the attorney-client privilege and get us ready to talk about exceptions to this duty of confidentiality. Okay, we've talked about this before. The attorney-client privilege is narrower, it's more difficult to get, but then once you've got it, it's stronger. It stands up in the face of lawful demands, for instance, during discovery and litigation. On the other hand, the confidentiality obligation is broader, easier to take hold, but once it takes hold, it provides weaker protection and can give way in the face of lawful demands. The relevant language for this broad duty of confidentiality comes from Rule 1.6a. So 1.6a gives the duty itself. 1.6b provides for various exceptions to that obligation, and we will talk in class about those exceptions. The relevant language here, of course, is what's in bold, and it's got to be related to the representation of a client. Contrast that to all the requirements of the attorney-client privilege. It's just a very easy trigger here. It's very easy to trigger this confidentiality obligation. Note that the client can give informed consent and say, yeah, that disclosure will help me. You can go ahead and do that. The rule also tells the attorney that there are some things you can reveal even without the client's explicit consent if it's impliedly authorized. For instance, if a client says, I want you to negotiate for me the purchase of that land, and during negotiations, it really hasn't come up with the client, but you need to reveal certain things about the client's background just as part of the negotiation to reach a successful end, you could do that because it's impliedly authorized to carry out what the client wants to get done in the representation. So you could think of the confidentiality obligation as rescinding each of the preconditions built into the restatement definition of the attorney-client privilege. So we have here again the privilege preconditions, none of them required for the confidentiality obligation. So it doesn't have to be a communication. It could be something that you learn by reading a document. It could be something you notice while you're out and about. But if it's relevant to the client's representation, if it's connected in some way with your representation, then that information is a client secret that you have to protect. It does not have to be made between privileged persons. It can come from any source, so you don't have to worry about who's in the room or who's an authorized agent or anything like that. I'll skip one for the moment, and it doesn't even have to be for the purpose of obtaining or providing legal assistance for the client. The source of the information can have any motive at all for giving it to you. The purpose of the source really just doesn't matter here. So all of these fall away. You're just asking, is this information that that pertains to the client's representation? If you've got that, you've got confidentiality. Now this feature of confidentiality is interesting and expansive. Remember, one of the requirements for the attorney-client privilege is that the communication has to be made in confidence. That requirement drops away here. The communication could be made at a cocktail party or in a public park or wherever. And in fact, selective waiver by the client is possible here. Unlike in the attorney-client privilege context, where once you waive as to one person, you've waived as to the world, here it may be that some people know about this information, but if it's not just completely wide open general public information, if some people don't know about it, then the attorney has an obligation to treat it as a confidence and not to repeat it to additional people. One interesting set of illustrations comes from the Nevada State Bar formal opinion from 2009 that's reprinted in your book or summarized in a newsletter format. Some interesting examples there, and I encourage you to work your way through the Nevada State Bar formal opinion and just work out for yourself why each of those examples would qualify as a technical breach of the confidentiality obligation. One reason that all of those are listed is because many of them are common small violations that lawyers carry out, and the bar is trying to stamp those out and reminding people, hey, don't get sloppy. This is sloppy. Probably not going to lead to major discipline, but nevertheless, technically a violation of the confidentiality obligation. Finally, the reading materials here return to the famous case of the missing bodies involving our creepy defendant and mass murderer, Robert Garrow, and his appointed attorneys, Frank Armani and Francis Belgi. We've already spoken about this case a bit during the introduction to the attorney-client privilege unit. It was relevant there because the attorneys learned certain things directly through communications from their client to them, but they also learned certain things about Garrow's previous acts by going to the scene, inspecting the bodies, taking pictures, and so that additional information would not strictly speaking be covered by the attorney-client privilege. It wasn't a communication, but it was protected, confidential client information. In the opinion in the case book here, we have criminal charges brought against Francis Belgi. I think also charges against Armani, but the case we have here is against Belgi. Charges for mistreatment of a body, for failure to report the presence of a dead body. So low-level crimes. Nevertheless, the court dismisses it, and along the way has some words of praise for the attorneys here for doing what is difficult. And this case is famous because it really highlights the tension between the attorney's confidentiality obligations and what the public really demands and expects, and what ordinary morality would require. This is one of those places where the lawyer's specialized duties run contrary to ordinary morality, and for that reason, over time, the attorney's confidentiality obligations have been modified. The exceptions have been expanded a bit, as we will discuss over during our next session in class.